Hi, this is Wagoner Attorney Stuart Ericson. Today we're going to talk about another defense to a charged crime, and this one's going to be the defense of duress. Of course, the most obvious defense is always self-defense, but there are other defenses. Entrapment we've talked about, and now duress. So a person charged with a crime is entitled to the defense of duress if that person committed the crime because of a reasonable belief that he or she was in imminent danger of death or great bodily harm from another. So let's look at some of these definitions. So number one, you commit the act because of some situation of duress, but of course it has to be a reasonable belief. And who decides reasonable? Well, again, at a jury trial, that's going to be the 12 people of the jury. They decide the facts. They decide a reasonable person, unreasonable person. So if your defense is I committed this crime under duress because I was in fear of death or great bodily injury, and here are the facts why, and the jury goes, what? No reasonable person would fear for their life under those facts. So that is one test of this, is the jury would have to believe that your belief is reasonable. And it can't be a fear of just some sort of injury for you to commit a crime under duress and to use this defense against the crime to be found not guilty. You have to be in fear of imminent danger of death, like they threatened this and I really thought I could die, or great bodily harm. So again, it's a pretty high thing that you have to be in fear of to commit a criminal act, to not be found guilty of it. Again, that's going to be very fact specific. And in some of these examples, a judge would not give the instruction of duress, because in that case there was no actual force or fear. There was no evidence shown. So the defense is going to have to come up with some evidence, some sufficient showing of evidence that there was some threat or facts or acts that would cause you to be in fear. And if the judge decides there's not anything, then you're not going to get the defense. Now, if there are some facts, then it will go to the jury, and the jury will decide that. So that's how that kind of works. There is a limitation to this defense as well, and the limitation is if you had a reasonably safe opportunity to escape from the danger or the situation. So if you're threatened, to commit a crime and there's a way for you just to leave or get away or somehow get out of the situation, if that's a reasonable opportunity, then you don't get duress, because a jury would be able to say, you could have left the situation. You could have walked away, driven away, whatever the fact situation could have been. So if there was a chance for you to get out of the situation and you don't, then this defense is not going to be available to you. So that, again, very fact specific. And again, as with the other affirmative defenses, once you make that showing of sufficient facts of this defense, the burden of proof goes to the state to prove that it was the crime was committed not under duress. So that's a big thing. And again, once you get past that threshold of showing some evidence, all these decisions are going to go to the jury. Again, juries decide what the facts are. It's not the judge, it's not the state. The juries decide would a reasonable person have acted this way? Was there a reasonable opportunity to get out of the situation or to escape? Juries decide who's telling the truth, who's not. So all of those are very fact-specific things that juries will consider. So if you have any questions about this defense, the defense of duress in any situation, reach out to me, Stuart Ericson at WagonerLawyer.com.